Welcome to Policy on Demand. I'm Sindhu Blume. The long-awaited foreign tax credit regs are out, and here to talk about what you need to know is Pat Brown. Pat, welcome.
Thanks, Sindhu. Good to be here.
So let's start with a bottom line statement from you about these regulations. They're 48 pages long. What's your primary thought about them?
Well, I mean, you said much anticipated. We've been waiting for these for a while, right? Since the final foreign tax credit regulations were released in December and published in January, there have been a lot of complaints from taxpayers that certain aspects of the regulations were just much too onerous and much too tight. And, gradually Treasury and the IRS sort of moved closer to the direction of taxpayers in recognizing that there were some areas that needed to be addressed. We can say that they have addressed some areas. These are taxpayer-favorable changes. That's great news. We know that there are other areas that they have not gotten to.
Okay, key takeaways.
So 3 main areas that are covered in this package. One is a highly technical change to the allocation and apportionment of foreign taxes. So I'm not going to really talk much about that. Minor change, highly technical. 2 other areas that we were looking for guidance because the government had, anticipated that they were going to come out with guidance in these 2 areas. One relates to the so-called cost recovery requirement. Okay, now what does that mean? Fundamentally, what that means is the final regulations when they came out provided that you can only take a credit for a foreign tax if it's an income tax. And if the tax does not allow the recovery of certain costs or expenses, under foreign law, if certain costs or expenses are not recovered, it may very well not be considered an income tax. The final regulations had a very, very tight standard. Essentially, a lot of taxpayers were interpreting the regulations to require very close conformity to US tax law principles. So that was an area that was much commented on, and the government has come out in these regulations with a safe harbor, with a more liberal general rule, which doesn't require recovery of all costs and expenses, but substantially all of each item of costs and expenses. So you see there a little bit of introduction of, I'll call it wiggle room, in the recovery of costs and expenses, along with a safe harbor. So clearly favorable changes there. There was also a lot of discussion from taxpayers about withholding taxes on both royalties and services. The government said they would address royalties. They also said they were not going to address services. So what do we get in the regulations? They addressed royalties, they did not address services. With respect to royalties, they've adopted a fairly limited, but I think helpful when it applies, liberalization of the standard for when a withholding tax on royalties can be creditable. It's going to overwhelmingly apply only when a taxpayer has licensed IP to someone for use within a single country. And there, the government has said essentially, we're willing to allow a greater deviation from the fairly strict legal standard we put up in the final regulations, which was the so-called place of use standard. Now the government has said, to the extent that the IP is in fact used in a single country, even if the foreign country's law is not a place of use standard, but rather a residence of the payor standard, we will still allow that royalty withholding tax to be creditable. So those are really the 2 main areas, cost recovery and royalty withholding taxes. On cost recovery, I would say more generous. On royalty withholding taxes, I would say narrower, but both are taxpayer favorable.
Pat, thanks for that. That was excellent and really crisp. And you don't sound terribly surprised by any of it. So I want to ask, was there anything surprising to you?
Well, somewhat surprising, but certainly very welcome. The government clearly in the area of cost recovery has decided that they would like to take the taxpayer concerns off the table. Now, it remains to be seen if they've completely done that, but the introduction of 2 different safe harbors, as well as the reintroduction of a more liberal kind of general standard around how closely do you need to conform to US tax law principles, as well as several examples illustrating the safe harbors. So the government clearly really went out of its way and provided, I would say, the bulk of this guidance, both in terms of number of pages and in terms of substantive changes, relates to cost recovery. And again, you can really see the government through this guidance essentially trying to signal they would like the issues that taxpayers have been raising to be taken off the table. They want to satisfy folks that close enough is going to be close enough, and there are a couple of different ways to get there.
All right, and speaking of taxpayer concerns, these are proposed, which means taxpayers can comment. So talk about that. Have you heard from any companies? I mean, these were just released a few days ago,
right,
but any issues that they're planning on commenting on?
Yeah, so I would say you're right, proposed regulations. And that's a lot more important in some respects than just what was released last Friday. It means the government has a regulation project open. It means that there will be an opportunity for taxpayers to come back in and say, hey, it's great that you provided this relief on royalties. Could we expand that relief on royalties? Could we expand it to other areas as well? Maybe on cost recovery, there might be some tweaks to the safe harbor that people will want to make. Look, we know when the foreign tax credit regulations came out, there were a number of areas that taxpayers had expressed a lot of concerns about. The government has taken significant steps with respect to cost recovery, more modest steps with respect to royalties, but that still leaves a whole lot of stuff that taxpayers have not had an opportunity to see changed in these regulations. So I would expect comments on those things. You mentioned that the regs are just out, and they are just out. So I think we'll be waiting to hear as taxpayers digest what sort of issues are coming up. But two questions that I've gotten. One question is, has this addressed Brazil and the creditability of the income tax in Brazil? And the answer to that question is no. So there's no change to whether or not the Brazilian corporate income tax is creditable. So that's something that the government is likely to get comments on from taxpayers. Another area I already touched on just very briefly, withholding taxes on cross-border services. This is one that we know is a big issue for a lot of taxpayers because to the extent you have services activities in the United States and they benefit a foreign party and there's a withholding tax imposed on those services, that is not creditable under the final regulations, for the most part, not creditable under the final regulations. And a concern from taxpayers is, does that essentially tell me that the only way to avoid double taxation is to shift those services activities outside the United States? Maybe not a great answer from a broader policy perspective. So that's the kind of thing I would also expect the government to get comments on.
Pat, this is great. It's just a few days after they were issued, and I really appreciate you taking the time to walk through them.
Happy to be here with you.
And a quick note for our viewers, you won't want to miss the Tax Readiness webcast about the implications of this year's midterm elections. A link to register is in the description of this episode, as well as the latest Week in Review with Rohit Kumar. The webcast is tomorrow and also hosted by Pat Brown. It is Thanksgiving week here in the United States, and to all of our viewers here, happy Thanksgiving. We'll be back on Monday, November 28th. Thank you for spending this time with us, and we'll see you next time.